Hey, in today's video, we're going over the basics of estate planning, how to make sure that you have your house in order. That's coming up next. Hey, my name is Mel Stubbs. I'm a financial planner at Christy Capital Management, where we're trying to help federal employees plan better for retirement. Today, we're talking about estate planning, and we're going to go over the acronym C.A.R.E. So C.A.R.E. stands for Creating Liquidity, Avoiding Probate Cost, Reducing Taxes, Executing Dispositive Documents. So liquidity means the ability to convert assets to cash without price concessions. There are a lot of expenses that occur at death. If you do some research, you'll see that sometimes the annual increase in the cost of dying has actually exceeded the annual increase in the cost of living. So lots of people will want to retire the mortgage at the death of the first spouse so that the surviving spouse and children are not burdened with this ongoing obligation. If that's something that you want to do, you need to have liquidity to be able to do that. The A is for avoiding probate. One of the advantages of probate is that it protects creditors by ensuring debts of the estate get paid. It has the ability to validate the will if one exists. Once the assets go through probate, it'll have a clean title for the heirs. Probate gives all concerned parties the ability to be heard and provides an orderly administration of the decedent's assets. The reason most people want to avoid probate is there are some major disadvantages. Probate can be extremely costly and complex. Real property that's located in a state outside the decedent's state of domicile may trigger a separate probate. Costs are typically a percentage of the assets. The process is usually very slow. It's filled with delays in transferring assets to the heirs. It's also open to the public, so there's no privacy. Most people want to pass property by some other means other than a will, usually by some form of contract. Now, there's a transfer on death for investment accounts. There's a payable on death for bank accounts. Life insurance, annuity contracts, and retirement accounts have beneficiary forms. And there's by operation of law for real property like joint tenants with right of survivorship, for example. So for example, with life insurance, the death proceeds, as long as they're paid to the designated beneficiary and not to the insured's estate, it will avoid probate. This is where planning is important. The more you plan, the more likely you'll have a smoother transition. Doing this correctly can cut down on cost, complexity, and time. Now, the R stands for reduced taxes. Some estate planners are only considering federal estate tax consequences when they look at this, but there's also federal income tax and applicable state income and estate taxes. And where this can get complicated is some people want to set up an irrevocable trust to give away property during their lifetime as to avoid the estate taxation at death. However, when one does that, they lose the income tax benefit that comes from the step-up in basis that results when appreciated property is held unto death. So in cases where the beneficiary is likely to sell the property and the property is highly appreciated, it may make more sense to hold the property to death so that they can get the step-up in basis. The income tax savings resulting from the higher basis may be more advantageous than trying to offset estate tax consequences. Another thing to think about the taxes at death is what happens to your traditional TSP or your traditional IRA. There's no step-up in basis for that. The balance in these accounts will be fully taxable. If these balances go to a non-spouse beneficiary, in most cases, they're only going to have 10 years to take the money out based on the new C.A.R.E. Act law. The fact that that window of time is now condensed down to 10 years can cause higher taxation for your heirs. This is where some tax planning can help, where you can look at what your tax bracket is while living compared to what your heirs' tax brackets may be at death. It may make sense to do some Roth conversions while living if you deem that you're going to be in the better tax bracket. If your heirs are going to be in the better tax bracket, it may make sense for them to inherit the money and then they pay the taxes on it at the better rate. The main idea here is to keep taxes in the forefront of your mind as you're planning this out. The E stands for Execute Dispositive Documents. Here there are different ways. The property can be transferred through the decedent's will and pass through probate. You can transfer it by the law of intestacy. This transfers property without a will and it transfers property not included in a will. Or property can transfer by contract and avoid probate altogether with beneficiary forms like life insurance, retirement plans, annuities. You can also have payable on death or transfers on death for other accounts. There are real estate deeds. Property can transfer by operation of law. Those avoid probate. So joint tenants with right of survivorship or joint tenants in the entirety or trust transfers. That way property avoids probate. Or you can do it by gifts and avoid probate. There are lifetime gifts and there are annual gift tax exclusions. There are some consequences of dying without a will. Many people believe that if you don't have a will, then your spouse inherits everything. And sometimes this does happen, but there are common situations where it doesn't. In many states, if you're married and you die leaving a spouse and 2 minor children, the probate property passes 1/3 to the surviving spouse and 2/3 to the children. It's very possible that the person who died may have preferred for 100% of the property to go to the spouse. Another problem is the lack of a will. It will always increase the cost of probate. It makes everyone's job harder. Attorneys and representatives may charge more because of it. The personal representative has to be bonded, and the estate has to pay that cost for the bonding. Now, this was a lot of information, and I'm not an attorney, and I don't claim to be one on these videos. But I wanted to bring to your attention this because the benefit of planning these things out can avoid a lot of problems. You can avoid dying without a will. So if you don't have a will, make sure you get a will. Lots of accounts can be passed by contract, by having a beneficiary form. Make sure you have the proper beneficiary forms filled out. Make sure you have primary beneficiaries and contingent beneficiaries. Make sure the money goes to whom you want it to go to. Make sure you have the title of your property done correctly. Many first marriages will have the property entitled joint tenants with right of survivorship, meaning the house becomes the other spouse's at the death of the first spouse. Now, many people that may be on a second marriage, where each spouse has their own set of children, may not want it set up this way. Tenants in common is where one spouse dies, their interest goes to their heirs and not to the other joint owner. Having this set up correctly is important. Now, hopefully you got some value from this video. Another video you should check out that's chock full of value is 11 reasons why you might want to turn on Social Security at age 62. If you need individualized help, go to ChristyCapital.com, click Talk to an Advisor. My name is Mel Stubbs. I'll talk to you next time.